Hi, my name is Andre Kilpatrick, and I want to talk about a case that arose out of Bloomington Normal, Illinois, McLean County in 2001. I was charged with aggravated battery against a peace officer and resisting arrest. The charges were sustained after I was harassed, falsely arrested, and excessive force was used to effectuate my arrest. At trial, my defense was that I committed aggravated battery against the police in self-defense. A previous motion of self-defense had been asserted by my prior attorney, who was a public defender. However, at trial, the prosecutor, Marina Wright, asserted that I was not entitled to the self-defense instruction as a matter of law. Judge William DeCarty overruled the prosecutor and said that as a matter of law, I was entitled to the self-defense instruction, and that whether or not I acted in self-defense was a question for the jurors to consider. So the prosecutor lost that ruling. However, after the noon recess, the prosecutor raised a new issue. She now claimed that she had not received a copy of the asserted defense of self-defense and was not prepared to proceed. Based on this bogus claim, the judge then withdrew the self-defense instruction. As a result of this egregious act, I was sent to trial without the self-defense instruction, which left the jurors without the option to consider whether or not I acted in self-defense, and left them with no choice but to find me guilty of aggravated battery against a peace officer. So essentially, I was sent to trial with no defense, since my defense was self-defense. So this in itself is a constitutional violation. Okay, at the sentencing, my attorney asserted that the self-defense motion had been filed by my prior attorney. Okay, this happened after I was convicted at the sentencing. And he also said that the self-defense instruction had since been located in the common law record. The prosecutor then acknowledged after the fact, now she claims that admits that she may have received a copy of the self-defense instruction before the trial, but nevertheless, I was not entitled to the self-defense instruction as a matter of law. Judge DeCarty then agreed with the prosecutor and denied me a new trial. So at the trial, the judge said that as a matter of law, I was entitled to the self-defense instruction. But to keep me from getting a new trial, he changed the ruling at the sentencing and now claimed after the fact that I was not entitled to the self-defense instruction originally, and he sentenced me to jail time. So in this case, a judge ruled against his own ruling, and the prosecutor admitted on the record to material misrepresentation when she lied during the trial and stated that she had not received notification of the asserted defense of self-defense. Then at the sentencing, she admitted that she may have received a copy of it before the trial. But nevertheless, I was denied a new trial. Okay, the case then went before the appellate court in Springfield, Illinois, and this egregious ruling and this farce of a trial was upheld by the appellate court. So in conclusion, I am a convicted felon, albeit a wrongful conviction. And, I wrote every organization, every acronym that I could think of: NAACP, ACLU, Department of Justice, ARDC, Illinois Judicial Commission, FBI, and none of them did anything. I am especially angry at the appellate court because their job was supposed to be to correct the malicious acts of the lower courts. But because of the quote unquote good old buddy system, I am certain that they were in cahoots with the lower court to keep me convicted, to keep me from suing the police who falsely arrested me, harassed me, used excessive force against me.